welcome back to Legal Brain. In today's class, I'm going to discuss yet another important area, that is the connection of Indian Constitution and Competition Act 2002. So I am going to discuss the topic Competition Act 2002 to part 3 of Indian Constitution. So this is an important area, an exam point of view, so try to understand. So as you all know, the Constitution of India is the prime law of the land, which is the supreme law in India, and which governs the rights of the people, fundamental rights, which is in our Indian Constitution, and that gives right to us our basic fundamental rights. And it ensures that every person living in India has basic opportunities and rights, and they live in their life in a dignified manner. So this is the basic right. And also, the Indian Constitution is considered to be the largest, and the main essence which is contained is the basic structure. So which include the basic structure of Indian Constitution, which includes our fundamental rights as well. So we should not, or like one should not infringe anybody's fundamental rights. And it is a very well-known premise that the Competition Act was framed based on Articles 38 and 39 of Indian Constitution, and Article 38 and 39, which mainly speaks about the conservation of wealth. So the main basic objective of Competition Act is that the wealth should not be, concentrated in few hands. The wealth should be distributed equally among all. So everybody should be able to reach that. So which provide that there must be policies to reduce the inequalities in income, or like possession or control of material assets are dispersed, so that they may benefit everyone. So everybody should get a benefit out of it. And the concentration of wealth should not be in a few hands who are rich. So there should not be any, concentration of wealth so and so. That means there should not be monopoly in market. So this is based on Article 38 and 39 of Constitution of India. Also, this is a well-known case, that is Minerva Mills case, which is a landmark decision that we study under Indian Constitution. So in this particular case, court held that 3 articles of our Constitution, and only 3, stand between the heaven of freedom into which Tagore wanted his country to awake, and the abyss of unrestrained power. So these articles are Article 14, 19, and 21, and we call them as golden triangle, and which is connected to each other, and these are the fundamental rights of human beings, and which is connected to our Competition Act. So I am going to discuss how Article 14, 19, and 21, that means the golden triangle, is connected to our Competition Act 2002. So basically, before that, Competition Act was introduced in 2002. As you all know, we have already discussed about that particular concept. So the main objective, or the scope and objective of Competition Act, was to regulate the market in such a way that no particular enterprise can exert influence in their favor. That means, as I've already mentioned, based on Article 38 and 39, there should not be monopoly in the market. So the main objective of Competition Act was to, the business enterprises work in an open market, and the entry and exit should be free, and there should be enough competition in the market, and there should not be any anti-competitive agreements. So it is also important that the ultimate consumers get the best product at the best price, and there should not be any discrimination. So these are the basic scope and objective of the Competition Act. So this Competition Act 2002 mainly leads to 2 establishments, and the first one is establishment of and functioning of CCI, that is Competition Commission of India, which is a statutory body which is having powers of civil court in order to regulate all the practices in the market. So if you have any grievance, you can file a complaint in Competition Commission of India. That is a statutory authority. So, and also with this, there is a concept called AAEC, that means appreciable adverse effect on competition. So appreciable adverse effect on competition says that if at all there is an appreciable amount of adverse effect, a negative effect, a detrimental effect in the market that leads to a monopoly condition, or that leads to an anti-competitive practice, it should be avoided, and the CC is having the power to initiate an action, to sue. They have suo motu powers, they have the powers to question the firm, and so on. So based on this, I'm going to connect it with constitutional articles. First one is Article 14. You all know what is Article 14, right to equality. So Article 14 makes sure that it's a fundamental right, which makes sure that all the citizens will be having a like equality, right to equality. It says that every person must be treated equally in the country. So based on Article 14 from our Indian Constitution, in Competition Act 2002, Section 3, 4, and 19 of Competition Act give effect to this particular fundamental right. And also, especially Section 4, subclause 2, subsection A says that the policy of differential discounting and pricing is discouraged, which means, if there is a discrimination and if doesn't, makes, fair play or that leads to an inequality which should be avoided. So basically, under Section 4, subclause 2, subsection A, under Competition Act, it says that if there is a policy that differentiates the discounting practices or it differentiate and causes a discrimination of pricing, that will not be fair. So which means that every enterprise at the same level must be given the same level of discounts. It should be same. There should be equality. And any deviation or any discrimination from the same will result in contravention of this particular provision. So you have to make sure these sections, Section 3, Section 4, and Section 19, which is connected to Article 14 of Indian Constitution. And also, under Section 4, subclause 2, subsection C of the Act denies practice of denying market access. That means the entry and exit in the market should be free. And it should not be discriminative in nature, and there should not be any inequality. And in its jurisdictional practice as well, the Competition Commission of India has adopted the same practice. And also there are certain case laws, which is landmark case law, which is very important. First one is Shamsir Kajaria versus Honda CL Cars India Limited 2014 case. So in this case, it was observed that a refusal to deal causes a denial of market access. So there should not be a denial of market access, which will be violative of Article 14, equality, and hence abuse of dominant position. This will lead to abuse of dominant position in the market, and which is violative of the provisions. And also, the next case is that in case of HT Media Limited versus Super Cassettes Limited 2011 case, this is another important case law in which Commission held that the imposition of high pricing by an enterprise will be deemed to be an abuse of dominant position. There should not be an abuse of dominant position when it comes to hiking the price, when it comes to entry and exit in the market, and so on. So under Constitution of India, various policies are enacted in form of reservations to ensure equality among all the firms. Similarly, Section 3 of the Act, which speaks about anti-competitive agreement, imposes conditions by virtue in which it can be identified if an enterprise or a group of enterprise have entered into a cartel. Cartel is defined in the Section 2, subclause C of Competition Act 2002, and the meaning is forming, informal or formal association of these members, the dealers, the distributors, and so on, in order to change the market situations, to fluctuate the pricing, and so on. So if you're forming a cartel, which will lead to an appreciable adverse effect in the competition in the market, and ultimately which will lead to inequality. So we have to ensure there should not be any abuse of dominant position, and there should not be any, monopoly in the market. And next is, I'm going to connect it to Article 19, which is very important, which speaks about the freedom of trade and profession. That's a fundamental right ensured in our Indian Constitution, and how to connect it with our Competition Act. So it is, the propagating that the principle is connected in Article 19, subclause 1, subsection G of Indian Constitution. And it is again connected, that is Section 19, subclause 4, subclause H of Competition Act states that any firm that creates any barrier in the dominant position, because of the dominant position which is creating any kind of barrier in the market, or which abuses the same, which is prohibited under this particular act. So the Competition Act makes sure that there should not be any entry or exit barriers in the market, so that, all the firms are free to enter and exit and to do their trade of profession. So Competition Commission of India, in its decisional practice of abuse of dominance, has also placed great importance on the entry and exit barriers. And also we do have section 4, subsection 2, subclause D and subclause C, which says that section 4, subclause 2, subsection C says that, which mainly speaks about under which a firm will be held for abuse of dominance if it denies market access, and which is violative of a fundamental right. Next is section 4, subsection 2, subsection D, which says that any firm which seeks information that is not relevant to the case and makes it the ground for entering into a contract can also be held liable for the abuse of dominant position. So this is how you connect Article 19 with our Competition Act. The last article is Article 21, freedom of right to live and personal liberty. And in judicial interpretation, as you all know, Article 21, which is having a wide, the ambit is really wide, and which also includes the concept of right of privacy. And it also held that even the state cannot violate such right. The Competition Act also tried to, have Competition Act have also considered Article 21 and its in its various provisions, and stated that as by virtue of Section 57 of the Act, the information sought by the Commission, that means CCI, Competition Commission of India, or the appellate tribunal cannot be disclosed without prior permission of the parties. So this is like right to privacy enshrined under Article 21 is connected with Competition Act by virtue of Section 57. And next is Regulation 35 of CCI, that is General Regulation 2009, which lays down a way which the parties can claim confidentiality about the information disclosed during the proceedings, in which Regulation 35 subclause C explicitly states that such confidentiality must only be sought when there is a risk that trade secrets, if made public, can cause harm to the business enterprises. So that is the essential criteria here. And also Section 35 subclause 8 is also very relevant. It says that the Director General can accept or reject the request. However, the parties can approach the Commission in case the request is rejected within 30 days. That is mentioned under Section 35 subclause 10. And since this procedure is appealable. So these are the major sections falling under a Competition Act. Also, by virtue of Section 36 of the Act, the Commission also gives due importance to principles of natural justice. So you have again learned about principles of natural justice, already all from part of here, both the sides and all these things. So say, since fundamental rights are the part of the basic structure of the Constitution of India, and any act or any rule or any legislation which is in contravention of this particular will be regarded as which is void or which is opposed to the public policy. It is imperative to see that Competition Act 2002 in hand in hand is connected with Constitution of India, and which adheres to all the rights and all the fundamental rights which is provided by the Indian Constitution. So this is the connection of the golden triangle, Article 19, 14 and 21 with the Competition Act 2002, which is an essay question. Thank you. I hope it's clear for you. If you do have any doubt, do comment below. Thank you.